So good morning, everybody. Welcome to the launch webinar of the STARLIGHT program. My name is Kirsty McCourt, and I'm one of the leads in this program, working together with the Hertie School and the Hungarian Helsinki Committee. And I'm really delighted to be launching this program today, that we have so many participants. And very grateful as well for the funding that is provided by the European Commission to launch this program and to get this program off the ground. So thank you very much for joining, and we're looking forward to spending the next hour and a half with you to give you a tester and an insight into what the STARLIGHT program will look like. And then to provide a practical perspective into the application process. So I'll start out just with a bit of a structure and some of the logistics, and then we'll move into the substance of the webinar itself. So we'll have a short introduction, and then we have around about an hour for a panel discussion with a series of panelists from practitioners to academics and the European Commission, where we'll give you a tester, a teaser as to what the STARLIGHT program will involve. And we'll try to make that a conversation, and there'll be a chance to ask questions. We'll then have the last half an hour of the webinar will be practically to look at the application process. We'll share the screen of the pages of the website that will go live later on today, and run with you how the application process will work. And again, there'll be a chance to ask questions. For some of the logistics, we are being recorded, and the webinar will go up onto the STARLIGHT webpage. For questions, we'd encourage you to use the Q&A function to put your questions there. In that way, we'll also collate them, and particularly for the logistical questions around the STARLIGHT program, we'll then provide as well on the webpage a summary of the answers of the Q&A. And then there'll also be the opportunity to raise your hand and take the floor during the Q&A sessions. And we'll be able to unmute your microphones for that. And then we'll share with you an evaluation from the European Commission at the end of the webinar, and we'd be very grateful if you can fill that in and complete it and return it to us. So I think those are the logistical points. So to give a very quick introduction, the STARLIGHT program is about the power of strategic litigation in the European Union. And you will have seen on some of the background material that we've recognized that strategic litigation is an underutilized tool for the protection of fundamental rights within the European Union. And so that's one of the reasons that we've put together this program that we're launching today, to explore with you all and provide a training as to how strategic litigation can become a more powerful tool for the protection of rights in the EU. And the Commission has also identified this, and that's why for the first time there is this new funding stream for strategic litigation within the European Union. And we're excited about the program, both because of the content of the program, but also the possibility then to be working with the Commission and others on the thinking around the development of strategic litigation. So with that very short introduction, I'm going to hand over to Marta Padavi, who is the co-chair of the Hungarian Helsinki Committee and one of the members of the STARLIGHT steering group, and one of the people who has been involved in some of the very new and groundbreaking cases on the protection of fundamental rights within the European Union. So I'm delighted to hand over to Marta, and she will give you a further insight into the program. Marta, the floor is yours.
Thank you very much, Kirsty, and a warm welcome to everybody from Budapest. I'm the co-chair of the Hungarian Helsinki Committee, and my welcome also is extended on behalf of our project partner, the Hertie School in Berlin, and particularly its Center for Fundamental Rights. We're very excited to work on this project that Kirsty already gave you a little bit of information about. And I'd like to give you a little bit of a background on why we teamed up, particularly with an academic institution, and why we think it's so important to talk and learn about strategic litigation in the EU for a human rights organization. Many of you might be familiar somewhat with our organization based in Budapest, which has been using basically all the tools and tricks of our human rights trade for the past 30 years. We use research, monitoring, policy and legislative advocacy, communications and litigation. Basically, I think all human rights organizations or human rights communities in the European Union are familiar with this. And we've always seen that these set of tools complement each other, and it's extremely important to use all of them. Litigation is crucial in this, but it will not work on its own in most cases. Beyond helping our clients from a strategic point of view, litigation is actually, in our thinking, a contribution to the rule of law and to protecting fundamental rights. Litigation can reinforce and advance them. While to lawyers this might also sound obvious, we know that our own clients, Hungarian citizens, refugees, many thousands of individuals who we've been helping over the past decades, they also see law as a very powerful safety net. Court rulings, in fact, can turn a claim and an allegation of a rights violation into an established fact, into truth, and this is very powerful. We so often know and hear from our clients who say that I knew I was right, but it was important for me to have the court confirm this. Everybody doubted me, but my lawyer stood by me and the judge believed me. Justice, indeed, as we all know, can be very powerful. Already about 20 years ago, we at the Hungarian Helsinki Committee, but also many lawyers will have familiar experience, we've gained substantial experience with the European Convention on Human Rights and on taking cases to the Strasbourg court. Just yesterday, for example, we celebrated a judgment that awarded damages to a victim of police ill treatment. At the same time, however, despite these important safety nets and landmark cases from Strasbourg, we know that litigation can also test the strength of the rule of law and fundamental rights. And in today's Hungary, fundamental rights and the rule of law are all coming under severe stress, and so are the institutions that are meant to protect them. Many of these have not been resilient to withstand the pressure of illiberalism. At the same time, we often hear skeptical voices doubting whether even court rulings from Strasbourg or Luxembourg can have any real impact against this politically driven erosion. In this process, we have increasingly sought out international standards, European norms, and fora to uphold rights and the rule of law. And at the same time, I must say, using EU law was not at all familiar to us for a very long time. EU law norms were not part of our everyday toolkit. We did not use these standards. We didn't know about them enough. But at the same time, we had to realize we must find new tools, new avenues to ensure that even if there's backsliding at home, by engaging the safety net of EU law, we could continue to stand by our clients and also to strive to protect the high level of human rights protection that everybody in Hungary should enjoy. So today we're still learning EU law standards. EU institutions, processes have though become part of our everyday tools in all our fields. And we use many of these words that Starlight will expand on and put into practice, such as preliminary references and infringement actions and case law of the courts of justice and the Fundamental Rights Charter, directives and regulations. These have become part of our own standard vocabulary in our office in Budapest. Also, in the past few months, our team in Hungary has been working very hard on the unfolding story, or perhaps even you can say saga, of tying rule of law standards to EU funds. And in this, we are seeing a great part of our advocacy and litigation work become part of the commitments that should be met by the Hungarian government. We keep the public interest in our focus so that Hungarian society, and not only a politically favored few individuals, would gain access to much needed EU funding. These rule of law standards and what are called horizontal conditions focus also a lot on the independence of the judiciary, but also include court of justice cases that Hungarian Helsinki Committee lawyers have been involved in, particularly in the field of asylum. We see this as a very unexpected and also very positive development. And it could be actually hugely important for protecting rights and the rule of law across the EU. So as we kick off this project with a lot of excitement and a little bit of anxiety, we look forward to learning and cooperating with you all so that we can grow together in our skills, in our knowledge through Starlight, and grow the power of fundamental rights and rule of law at a crucial moment in Europe. Thank you very much.
Thank you very much, Marta, for that very powerful introduction. And I think, as Marta said, what we want you as potential Starlight participants to be able to do is to, as Marta said, turn experiences into legal precedent and to become familiar with all of those terms and ways in which you can use EU law that have been relatively unfamiliar with those of us in the human rights community to date. So I'd like to turn over to the panel. And we have a mix of panelists from academia and from human rights organizations. And that's also reflective of those who will be leading and teaching under the Starlight program. The idea is to bring both that academic and research experience together with the practical experience. So I'll introduce each panelist as we come in. But I would like to start off by introducing Professor Başak Çağlı, Professor of International Law and co-director of the Center for Fundamental Rights at the Hertie School in Berlin. And if I can put the first question to you, Başak, if you can provide, from your perspective, an insight into the power of strategic litigation and why to date it has remained an underutilized tool for the protection of rights in the European Union. Thank you very much.
Thank you. Thank you very much, Kirsty, for this introduction. And let me just warmly welcome everyone who has joined us today at this panel, also on behalf of the Hertie School. The Hertie School is an international school of public policy based at the heart of Berlin. And it offers interdisciplinary master's, doctoral programs, as well as executive education programs. And the language of instruction of our programs is English. We're at the heart of Berlin, and we're very happy to be contributing to the international environment and the discussions. The Hertie School has also a number of schools of and centers of excellence that is part of the school. And these centers of excellence are focusing on the fields of fundamental rights, study of the European Union, digital governance, international security, and sustainability. And this program, the Starlight program, really brings, and really I think is very exciting for us at the Hertie School, because it's at the intersection of two areas of research that we do at the school. That is fundamental rights and the study of the European Union and its law and governance. So I'm very excited, I'm very delighted together with my colleagues to be able to provide some academic input also from our research to the STARLIGHT program together with all of our partners. So coming to your question, Kerstin, about the power of strategic litigation, it is going to be something that we will be discussing at the very early on stages of the program. And I think it's a very important discussion about what we understand when we talk about strategic litigation, how we define it, what are its advantages, what are its disadvantages, what is its power, what are its shortcomings. I think these are very, very crucial questions that will also be part of the early setting up or the sort of the introductory sessions that we will have. I think one way that we can define strategic litigation, and I have to say there are many, but I think here is one way, maybe we could do that, is to think about the use of courts in one case or litigation in one case for the benefit of the many. Now, this is an important and interesting discussion because strategic litigation, of course, is about the case, but it is also more than the case or the individual or the applicants that are engaged in that case. And how that works, how one can work for the benefit of the many through a single case has been a very long-standing discussion also in the academic research on strategic litigation. And what do we mean by the benefit of the many, you can say? And of course, in the human rights context, in particular, we define the benefit of the many as the litigation having outcomes that is beyond the reparation or the compensation that is provided to a particular victim. And in particular, that we are aiming, seeking to give effect to reforms of law, policy, and legal practice with the aim of enhancing the protection of human rights. But I think strategic litigation in particular, as Marta has also just highlighted, in the context of Europe, and in particular in the context of the European Union, also enhances not just benefits for rights or increased rights protections, but it also has the potential to have very significant institutional benefits for both the protection of the rule of law and its institutions, as well as the protection of pluralist democracy. So I think the benefits are not just about benefits to other persons' rights, but also to the institutional safeguards that actually enable the protection of human rights, protection of fundamental rights. I think another very important benefit about strategic litigation is not just to think about it through legal precedent, which I think is very important, or legal reform, or improvements in the legislative structures and so on, but also its power in awareness raising, especially within broader public and also within social movements. And of course, we will also have discussions about that, that you might both have impacts that are legal or legally oriented, but also might have social impacts as well. And I think that this is also a very important part of thinking through human rights-based or human rights-focused strategic litigation. There are doubts, right? There can also be points that could say that would criticize the use of strategic litigation. And I think we should also be really mindful of those. And some people say, well, what about using other forms of action, political or social action through political means? Is there not a problem of using courts instead of using democratic procedures and politics? And I think we will debate and discuss that because there's a very fine relationship between legal mobilization and political or social mobilization. And we as academics would be able to discuss and reflect these with the participants as well. But of course, strategic litigation can be powerful in supporting other forms of action. And I think this is really important, that it is supportive of and not only at the expense of other forms of political or social action or mobilization, but also it's incredibly powerful. And I think this comes back to where we are in Europe today, is that when these channels are blocked, so you cannot really go through political forms of mobilization to protect fundamental rights, then it also becomes a very important, very powerful tool to be able to address these challenges that are part of the political systems that we're facing in different parts of Europe as well. And of course, strategic litigation also gives voice to those who cannot access political processes. And this is very significant, in particular for migrants, for asylum seekers, and for refugees, because they do not have access to political processes. And I think in that context, strategic litigation does give a very important voice, which they cannot have through democratic procedures. So the voice to the marginalized, I think, is very, very important. And we do have a particular stream on asylum and migration and the use of strategic litigation in that context in this program, which I think is going to be exceptionally valuable, also exceptionally powerful. Now, in the EU context, strategic litigation is relatively new. I wouldn't say it's all new. I wouldn't say it's all brand new. And there are some amazing practitioners here today with us, and I'm sure also amongst the participants who have used litigation and have utilized the EU laws and various procedures. But I think there's a common understanding that it is still relatively new in the European context. And perhaps there are a couple of reasons for this. One is that especially the human rights lawyers, human rights NGOs, the human rights communities have been a lot more familiar with the European Court of Human Rights and using the European Court of Human Rights to Strasbourg and its case law and its procedures in order to advance human rights, democracy, and the rule of law. So one explanation is just that we know a lot more about Strasbourg or the European Convention on Human Rights than maybe in comparison to the EU Charter for Fundamental Rights, EU laws and procedures. So I think this is one way of approaching it, that it is maybe a little bit of a variation in the knowledge that we have of one system compared to the other. And maybe other lawyers in the EU know more about the EU laws, but perhaps less so is the case for human rights lawyers or the human rights movement. So I think the STARLIGHT program will be able to remedy this aspect of our knowledge gaps, perhaps a little bit. But of course, I wouldn't want to overplay this. And I'm sure there are many experts here with us in the room who would have used these tools as well. There are also a lot of institutional differences between using EU law to litigate as opposed to the European Court of Human Rights. There are big differences as to standing, how we initiate litigation in the context of the EU, the preliminary reference procedure, and so on. So there are lots of institutional, I think, differences that one has to navigate in different ways when using EU law compared to Strasbourg, or perhaps also comparing the United Nations human rights treaty bodies and mechanisms. So there are a number of reasons, I think, where we can think that, would explain in different ways why this is a relatively new area, but an area that is becoming incredibly crucial. And I'm really looking forward to STARLIGHT making a very big contribution to both the lack of maybe a very widespread knowledge of these mechanisms, but also the lack of experience of learning from one another when using EU in this context.
Thank you very much, Başak, and for providing the great breadth of the potential impacts of litigation, and then giving some of those insights into why it's been in some ways underutilized. And we'll really delve into these questions in the first module of the STARLIGHT program. Maybe just to follow up on that, and we've talked a little bit, and you mentioned experience before the European Court of Human Rights. And if you could just highlight maybe one aspect of lessons that have been learnt from the Strasbourg Court that can be applied to the Court of Justice of the European Union.
Thank you. I was reflecting on this question a little bit this morning, and I think one answer that I have for you, Kersti, has to do with maybe the interactions or the very successful interactions that the civil society, the human rights lawyers, and the academic community has really managed to establish in the context of the knowledge and the use of the European Court of Human Rights. So if we look at the field of European human rights convention and litigation around it, what I see is that there's a very successful feedback loop between academic research on the European Convention and its case law, the knowledge of that research amongst human rights practitioners and human rights lawyers, and the circulation of the knowledge that is generated by litigation back into academic research. This is, I think, an outstanding and a wonderful development that has happened. I don't know how we managed it, so it's maybe helpful to reflect on it, but there are very strong links between academic research, strategic litigation, activist communities, and human rights organizations in the field of the use of the European Convention on Human Rights. This meant that not only the academic research has been internalized by litigators and human rights lawyers across Europe, it also meant that human rights lawyers have taught a lot of new things about the convention to the academics. And this is an incredibly healthy, I think, conversation that we have had. Looking at the use of EU law, the Charter for Fundamental Rights, and litigation through the use of EU law and the Charter, I think there's an area that we can learn a lot from how this very productive and also co-productive, I would say, knowledge and experience between practice and academia have been really sustained in the case of the European Convention. So this is an area I think we can learn many lessons. And coming back to Starlight, I think this is incredibly, again, an important aspect where I think this program is going to really enable that two-way conversation in a very significant way. I'm going to be taking part in this program, but also I have colleagues, experts, amazing experts in EU law and governance. Professor Mark Dawson also has worked extensively on fundamental rights, and Professor Catherine Costello, who's an expert on EU and asylum, both before the European Court and the Court of Justice of the European Union. And I think taking part in this training or in this knowledge program, I would say not just training, but I think it will be a much more of a two-directional knowledge gathering exercise, is going to perhaps remedy some of the shortcomings about the academic and the practitioner world using the EU, using the Charter for Fundamental Rights to advance both rule of law, but not only rule of law, but fundamental rights protections in the context of migration, asylum, and criminal justice.
Thanks very much. And I think that's also one of the exciting elements that, that this will be a learning and exchange experience. I'd like to turn now to Professor Patrick Krauskopf, who is from the Zohr School of Management and Law, and will also be one of the professors and lawyers who provide training during the Starlight program. And Patrick, you're a lawyer who's worked in many areas, and also particularly competition law, which is an area where there have been a lot of cases litigated before the Court of Justice of the European Union, and so provides that contrast to the smaller number of cases that we've seen to date in the human rights field. So I'm wondering if you can just share a little bit from your experience as to what you see that we can learn from that perspective. Thank you.
Yeah, thank you, Kerstin, for inviting me to join this presentation today. And I feel very privileged of being part of this Starlight project run by Hertie School. And obviously, I'm not a human rights lawyer. I'm a pure competition law enforcer. And the idea I was asked, because in competition law, we are used to deal with strategic litigation in order to enforce, for instance, consumer rights. And I became aware when I was the vice chair of the Swiss competition agency, and had also the privilege of writing the competition law of Switzerland 15 years ago. And, you know, if you want to enforce an idea, competition law, human rights, you always have to show the benefit to the general public, to the different political stakeholders of enforcing a law. And one important tool of enforcing a law is basically strategic litigation. Maybe take place in front of a district court somewhere in a jurisdiction, or you can reach out to a supranational level as a European tribunals. And because I'm also a lawyer here in Europe and the US, I guess the idea and the added value I hope to bring to the project is, how do you design, how do you choose the jurisdiction where you're running such a litigation, such procedures? And what I'd like to do with our students, our participants during the course of this project is really to not only to design to ask yourself, what is the aim of your litigation? Litigation is only one part of what you want to achieve. Litigation is one part of what we call advocating something. So in competition law, advocacy is a very important tool, because you want to show that a legal system, that human rights, and I'm talking now for consumer rights, competition law is all about consumer rights. And to show why enforcing in a public way, public enforcement or private enforcement, why it's so important that tribunals are taking a case, are judging a case. And you don't want to leave everything just to the judge to tell you, okay, I will follow your legal arguments or I will deny you. Litigation starts, at least in competition law, and I guess it's going to be very similar in human rights issues. It starts long before you choose to take one case. One case. Strategic litigation means you take one case, one leading case. And through this one leading case, you want to have a huge impact in the entire public courtroom, and you also want to influence other jurisdictions, other courts to follow a certain legal guidelines. And in what I'm doing now for 6-7 years here at Zurich University School of Management and Law, we are running litigation PR classes, and we are also having huge conferences. And so the question is gonna be, how do you design, how do you choose, how do you enforce what you want to be achieved? And this starts, long before you go with your lawyers into you walk into a courtroom. It starts in competition law in the US when we decide to have a leading case, or in Europe when we decide to have a leading case. This starts 2 years, 3 years prior, even before filing your claim with the tribunal. And so what is important? What are the different stakeholders you need to address prior to engage in the litigation? This is certainly, it's going to be one very important part of our project. And the second thing is going to be, how do you deal with the ongoing case once you have filed, once the year-long litigation is gonna start with public hearings and so on? What is important during this procedure? What you need to have a story to tell, not a story to tell only the judges who are gonna decide in this leading case. You need a story which is also being accepted by the media, by the general public, Why that's so important? Because you don't know, and this is going to be the third part of strategic litigation. It might be that you lose into in the courtroom, but even if you lose in the courtroom, you want to be a winner in the public courtroom. So how are the media, how are the political world going to take your case afterwards? And it might be that we have to change the legal setting after such a case. So this is strategic litigation. It starts way before you file your complaint, and then how do you deal with the topic during the litigation, and how do you make sure at least that even if you lose, that the general public, the political surrounding, the economy, the scientific world is gonna follow you. So this is what I guess we can learn from competition law, and to transpose it, to translate it into human rights litigation procedures. So this is what I would like to bring into this class and into this project, Kirsten.
Thank you very much. And thank you for providing that insight. And during the program, all of the participants will have a chance to not only develop the legal arguments in a particular case, but as Patrick has just been outlining, to develop a litigation strategy. And so thinking, as he's just said, from the very beginning of the first thoughts about what case and where it would be strategic to take that case. And Patrick, if I can just ask you to say maybe one more thing, particularly around the communications and the public relations. That's something that you've worked a lot on, and is also something that we will, during the skills part of the program, will be focusing a whole module on. So if you can just briefly say one more word about the communications and public relations.
Yeah, absolutely. I have to start. I always disappoint my students studying law, or my colleagues, my lawyers and other colleagues. You know, law is just 20% of your success. Certainly, you need to have a solid legal basis on which you base you need solid fundamentals, solid arguments, etc. But this is only 20% of your success. 80% is gonna be communication. How do you communicate complex issues with the tribunal, with the judges? How do you communicate complex cases? Human rights cases are oftentimes quite complex, because it's going to affect the entire economy. It's going to affect your own. If we talk about the economy, it's going to affect your supply chain. You know, you want to enforce in the economy human rights. A European company has to look at its supply chain in Africa, in Asia, in South America. And so it's very complex. It might be costly to handle such cases, but we need to address the benefits of enforcing human rights. And this is not a legal argument. Yes, as I mentioned and my colleagues mentioned, and the project is about strategic litigation, but 20% success rate, legal, 80% communication within the courtroom and in the public courtroom. And there, it's going to be a fascinating project with Hertie School, not to have this kind of interdisciplinary approach, how to communicate, how to get the majority of the public, the majority of the political world, how to convince the majority of everybody to join this case. And by doing that, and we have so many cases in competition law where we were able to show with economical reasoning, with social politics, to show how important one case is for everybody in our communities. And so, Kerstin, it's going to be a very fascinating program and project, and I'm really looking forward to working with you, with our students, our colleagues in this project.
Thank you very much. And it's, I mean, we've heard it before, but it's always good reminding ourselves of that element that that so much is about how we communicate. So I'm now going to turn to Grusha Macevic, who is a lawyer at the Hungarian Helsinki Committee, and someone who has worked on quite a number of rights-based cases before the Court of Justice of the European Union. So Grusha, it would be really great to hear from you about your insights into one of those cases. What was your role as a human rights organization? And what were the key lessons that you learned from that litigation? Thank you very much.
Thank you for the questions. Well, as you know, in Hungary, asylum legislation was amended in a way that is not compatible with EU law. But since controversial provisions are part of domestic legislation, it is difficult to litigate, as the courts tend to only examine compliance with domestic legislation and are not often open for the arguments that such legislation might be against EU law. Instead of presenting a concrete case, I would rather speak about the whole legal battle, which we fought for 5 years, and when we litigated at 4 different fronts: domestic courts, ECHR, CGU, and UN Working Group on Arbitrary Detention. The main issue was whether asylum seekers kept in the transit zone were detained or not. From the very beginning, we firmly believed that they were, and that such detention is not in line with the EU law and ECHR. On the contrary, according to the Hungarian legislation, this was not detention, therefore there was no detention order issued, there was no possibility of judicial review, of legality, and so on. Domestic courts were reluctant to go against national legislation and refer a preliminary reference, and for the first 2 years we had no success. Then finally, the regional court in Szeged started to release people who were there longer than 4 weeks. But this didn't please the government, and they changed the jurisdiction rules. The competence was transferred to Budapest, and the judges there did not agree with the approach the Szeged court took, and people remained detained. In 2017, ECHR issued a judgment, Ilyas and Ahmed, confirming that people are deprived of their liberty in the transit zone. But the government appealed, and the Grand Chamber accepted the referral. What followed was a deep shock to everyone. In 2019, the Grand Chamber ruled that the placement in the transit zone was not detention. You can imagine the despair that we faced. But luckily, it didn't last long, because just a few months after, a domestic court finally referred a preliminary reference to the CGU. Why suddenly now, when there was already a negative judgment in Strasbourg? First, I believe because we managed to trigger the jurisdiction of the Szeged court instead of Budapest court. The preliminary reference was born out of an omission appeal. We sued the immigration authority for not issuing a detention order, and that's how we could use different jurisdiction rules. Second, I think the humanity factor also played an important role, because the applicants in these 2 cases have been kept there for more than a year, including a 10-year-old boy. So, on 20 March 2020, CGU ruled in FMS and SA case that placement in the transit zone indeed is detention and that it was unlawful. Despite initial reluctance, the government nevertheless complied and released everyone. Almost 300 people were freed, and the era of unlawful detention that lasted for 5 years was finally over. After that, we started to get positive judgments from Strasbourg court as well. not in all cases, but only in those where children were also included and when detention lasted for longer. But UN Working Group on Arbitrary Detention also issued a positive opinion in a case of a single man without specific vulnerabilities. So a key lesson for us was first, well, not to give up. Then second, to rely on the EU law as it gives stronger protection, at least when it comes to the right of liberty of asylum seekers and migrants held at the border. And third, that you are not alone in such battles. We have received great support from other NGOs, from academics, from people who believed in the same as we believed. And by this CGU case, several anomalies of the Hungarian asylum system were addressed, not only detention, but what is really important is that the court emphasized that the principle of primacy of the EU law and the right to effective judicial protection guaranteed in Article 47 of the Charter gives power to the national court to rule on the lawfulness of detention despite non-existing domestic provisions and to release people who are unlawfully detained. And I believe this is something that the STARLIGHT project would try to give you, to empower you in order to litigate in front of national courts how, despite problematic national legislation or practice, the national courts can make things right by applying EU law directly. Thank you.
Thank you very much, Grusha. And this really touches on so many different elements, and also then the power and the interrelation between different courts and different rulings. So thanks very much for providing that insight. So I'd now like to turn to Ingrid Bolanda-Tordino, who is the head of unit of the Fundamental Rights Policy at the European Commission. And it is under the funding stream of DG Justice that this program is funded. And we're very grateful to be receiving that funding, but also, as I said, to be kind of moving on a journey with you in this process of learning and developing strategic litigation and enforcement of the rights under the Charter of Fundamental Rights. So I'm very pleased that you were able to join us for this webinar, and the floor is yours.
Thank you very much, and really thank you for inviting me to this event. As we have heard, strategic litigation is extremely important in enforcing human rights and fundamental rights. And you're on a journey, as you say, like a pioneers for the commissions as well, because we have just started to fund projects, and you are among the first in the first round. So I will set out a few of our thoughts about why strategic litigation is so important in the work on enforcing fundamental rights in the EU, and also give you a little bit more insight in how the funding works. Without going into too much detail, but then I invite you to ask questions if you want. So we are convinced that strategic litigation is really important, as I said, to advance the protection of fundamental rights in the EU. Legal practitioners and civil society organizations who are engaged in strategic litigation, we believe, play a crucial role, not only in assisting people and the victims of rights violations, but they also ensure that we have better access to justice and fight for their rights. And this was recognized by the Commission in the 2020 strategy on strengthening the application of the Charter in the EU. And this strategy highlighted that strategic litigation contributes to a more coherent implementation and application of EU law and to the enforcement of people's rights. So, of course, to be able to have successful litigating cases of violations of fundamental rights requires legal capacity and specialized knowledge on the applicable legislation and the related case law. So as we have heard also from the previous speakers, this is a tool that you have used, the practitioners have used, the CSOs, mainly in the court, in the Strasbourg Court on Human Rights. But in recent years, there's an increase in strategic litigation at both national level and at the European Court of Justice in Luxembourg, with cases related to the EU Charter on Fundamental Rights. We have heard a few examples. I can also add the Coleman case that was a successful case, which is also bringing change in the way the EU is legislating on the recognition of same-sex couples. So I think that is a successful strategic litigation that we can recognize as well. It's important, the role of the civil society actors, the CSOs, the national human rights institutions, the equality bodies. Their role is instrumental, and the lawyers who work in these organizations. They are uniquely placed to combine being close to the victims and have the knowledge that is required to support them and to be able to proceed in court. But this also shows that it's not only about law. There's also a need to go beyond the development of a robust legal expertise. We think that the success of litigation initiatives requires really good communication skills, advocacy work, and community engagement to reach policymakers, ensure media coverage, mobilize public opinion, and maintain victims' engagement in the process, and ensure that decisions are enforced, and also where necessary, lodging appeals or additional filings. So it's a combination of this legal expertise, but also the more advocacy, the engagement in the communities, and of course having this right-centered approach to ensure that the victims are heard and assisted. This is why we have designed this new funding opportunity under the Citizens' Equality, Rights and Values, the so-called SERVE program, to cover all these aspects. We have recognized this specific priority of strategic litigation by designing a specific priority under the SERVE call for proposals that are dedicated to increase the application of the Charter of Fundamental Rights. So it's a specific priority under the program. So we intend to continue. We had the first call already, which your project is part of, but we intend to continue these activities because it's really key to fight for our democracy, to ensure the rule of law, and to do everything we can to protect fundamental rights. So the aim here is to strengthen the knowledge, capacity, and ability of practitioners, legal professionals, civil society organizations, human rights bodies to effectively engage in litigation practices at both national and European level. This will improve access to justice, as we said, and enforcing the rights under EU law, including the Charter, through training, knowledge sharing, exchange of good practice. So this is why we have focused our call on the upstream work to build capacity for litigators. So as I've said, it's about training, knowledge sharing, exchange of good practice, analytical activities, data collection, research, and creating tools or databases to enable litigators to improve their knowledge about these tools and also to bring cases to courts. We think that having this approach is a sustainable investment, is rather than financing direct litigation costs of individual cases. So we're convinced that by this call, this funding stream, we can empower civil society organizations and rights defenders and this can have a long-term impact on protecting fundamental rights and the rule of law in the EU. So the STARLIGHT project is one of the pioneers in this. It's not a new area, of course, but it's the first time the Commission is funding specifically these projects. And we selected the project because it covers not only the fundamental rights aspects related to the Charter, but it also goes further to cover issues related to the rule of law, including the protection of civic space. And the Commission is now looking very closely on how we can protect, support, and empower civil society actors. So this fits very well in another priority of our work. It's a very value-based project. It shows how EU values are interlinked and how the Charter can be used to protect those values. Another interesting aspect of this project is that it also looks at practically how to increase the use of the preliminary ruling mechanism. You talked about it already in the panel. This project will help lawyers identify the judges that are more likely to refer and equip them to prepare the request for the referral. This creates a stronger link between the national and EU level, as EU law is, of course, embedded in the national strategy at an earlier stage. This is in view of possible referrals to the European Court of Justice if the situation is not solved at the national level. So it's a strategic thinking that we really liked when we looked at this project. The European Court of Justice has always taken a strong supportive approach in cases on fundamental rights to clarify the content and the essence of the rights enshrined in the Charter. And the case law, as you know, is growing by the day. So this is a really important thing to highlight and work more on. So now for the future, the Commission, the team here, and my team in the DG Justice, we continue the work. There will be a new call for proposals, also with a priority on strategic litigation in this year's work program. The new call will be open as from, in a few days, the 24th of January, and it will run up to the 25th of May. So you have until 25th of May to apply for funding. Last call, we had 2 million euros to fund 7 projects. And this time, I cannot give you a figure, but it will be slightly more. So I hope that we can continue increasing the number of projects, because we received a lot of really good proposals. We can possibly have a few disappointed participation in the room here today, but the competition was rather fierce, given that we didn't have more than 2 million to fund projects, but we hope that we can continue funding more projects in the future. So I know you will also speak a little bit more about how to apply for funding in the next session in the webinar, but I'm here all through the end of this webinar here today, so we can answer some questions if you have. So I wish you really good work and good luck on this project. I'm sure it will be great quality deliverables, and we're looking forward to see the results. Thank you very much.
Thank you very much, Ingrid, for both sharing the Commission's insights and your thinking into why and how you're supporting strategic litigation, and also, of course, we're very pleased to hear that there will be new and even slightly increased funding for further projects. So I see we have a couple of questions in the chat. We have a few minutes now to take questions. Please